for
Nsem-Pii will honor more, now Nsem so it is. Utie, now share on my YouTube channel.
Be the first to know Nsem-Pii TV.
Aye butu. Ene saying Kwame Bafo Abronye drags Iyoko Raymond Acha, NIB, and Attorney General to Supreme Court over excessive bail conditions. Bono Ashanti, Bono Regional Minister, Chairman of the New Patriotic Party, NID Iyoko, NIB, and Attorney General across Supreme Court. And saying, Yabakaya, I want to me arrest. Iyoko demanded to the tune of 50 million Ghana cedis. And no man, net da Iyoko 6-7 days. Abra wonya bail. Go into me meet conditions. Nansenya Bafa Stock CEO and also Yecheno on any year. They demanded to the tune of 110 million Ghana cedis before say the bail conditions on Amawomo. And no Ama Iyoko is going out of bounds. NIB, Attorney General. Omo breach the constitution. Constitution is what you be. Now man bail conditions now meet here within 48 hours. As ordinary court. But in this case, Yahuze Iyoko echo. Now beyond 48 hours won't meet bail conditions cry. Still, now that's so Edan as well. Now Abronye a Supreme Court will file rates. Na yɛnkɔ rate no mu na yɛnkɔhwɛ neɛ ɔwɔ mu. Ɔsɛ the action. Ɔsɛ in a rate filed at the Supreme Court, Abronye is asking the Apex Court to declare as unconstitutional the continuing detention of persons by Iyoko and NIB beyond the constitutional mandate 48 hours. Particularly in instances where bail has been granted, but the person or the accused are unable to meet the bail conditions imposed. So the action brought under Article 2, Clause 1. Now, you quote Article 2, Clause 1 of the Constitution or say, a person who alleges that any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. Abronye say, per Article 2, Clause 1 of the Constitution, say obi ye mmara bi na ofuni say etia the Constitution, now the call Supreme Court. Now Supreme Court ama interpretation to that effect. Owie na osan call Article 130, Clause 1 of the Constitution. Article 130, Clause 1 of the Constitution, or say, subjects to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of the Constitution, the Supreme Court shall have exclusive original jurisdiction in all matters relating to the enforcement or interpretation of the Constitution. And the Constitution, the Supreme Court on said, matters of human rights, they are also on interpretation. Now, you call rates no. Said them kind what dragi Iyoko NIB and Attorney General to the Supreme Court, and I was see one the Supreme Court and declare that effect. And first declaration was say, Abronye is seeking several declarations from the Supreme Court, including 1. A declaration that Article 14, Clause 3 of the Constitution applies to situations where an individual remains in custody despite being granted bail, but is unable to meet the bail conditions. Now, Article 14, Clause 3 of the Constitution, I can't pay face say, so which will be, so you could be, NIB will be. That's the bail conditions and within 48 hours. Until me meet bail conditions now. Near was a enforcement institution in say ordinary court. Enti yankin kind Article 14 verse 3, clause 3 of the Constitution was saying, for the purpose of bringing him before a court in execution of an order of a court in the case of a person suffering from an infection or contagious diseases. Yes, cited the case of Untumi. I realize that Untumi na wayare. Untumi yare no mu nyinaa mu no. Yoko detain no for 6 to 7 days. Now, no constitution is no. So Untumi meet bail conditions in there any yemfa no emra court. Now, 2, Abronye is seeking the declaration that Iyoko and NIB violates Article 14, Clause 3, when they detain suspects beyond 48 hours on the grounds that bail conditions, however excessive, have not been satisfied. The Supreme Court no declare say Iyoko detain will be more than 48 hours on the pretense say omo ntimi meet bail conditions. Na bail conditions ni excessive no. Supreme Court declare say unlawful detention. 4, 3 or say a pronouncement that the two agencies lack constitutional authority to detain any person beyond 48 hours without judicial authorization, even when bail conditions has been granted but remains unexecuted. Or Supreme Court no any declaration on Iyoko and NIB say they should never and ever detain or be more than 48 hours in their premises when a granted bail has been given but is unexecuted. Or say a finding that the practice of imposing punitive or unattainable bail conditions amount to a constructive denial of bail, which undermines the spirit and letter of Article 14 of the Constitution. Abronye Chiremwa, the bail conditions and say NDC, Iyoko, NIB, Attorney General, Omode ma nkrofo omo suspect omo, not confirmed cases. Chirem say chese omo adwen say omo mpese nipa no. Ebe ma ne bail enti ye de tabo bail conditions eso eche ne capacity na de be ma no. Na no Supreme Court declare say sa de na unconstitutional. Now these institutions, Iyoko, NIB, no, omuni jurisdiction, they don't have the capacity, they don't have the power to do those things. I say an order directing Iyoko and NIB to ensure that all persons arrested and granted bail but unable to meet the conditions are either released or brought before a competent court within 48 hours of the arrest or detention. Failure to do so, the plaintiff argues, should render any continued detention unlawful. I say, Abronye say, Supreme Court enhyɛ Iyoko ne NIB sɛ wɔn kyerɛ obi a sɛ 48 hours ni twam na still wɔn keeping under detention a Supreme Court declare sɛ ɛyɛ unlawful na ɛfiri na ɛkɔ no nyɛ adeɛ sɛ wɔbɛtumi ayɛ biribi saa. Ɔsɛ and any constitutional orders that the court may deem fit to give effect to the fundamental rights guaranteed under the Constitution. Afei, Abronye ɛsan siki court sɛ mmara biara anaa constitution no nea ahyɛ these bodies the NIB, the Iyoko, and the Attorney General Office a ɛwɔ sɛ wɔn de yɛ mmara kwan so na wɔn nyɛ no. The Supreme Court should invoke or make that declaration to ban their actions from infringing on fundamental human rights and freedom of individuals yes suspected of criminal activities. Now this is the action Abronye take butu.
Anti secret bia wo NDC mu no Abronye de beba omo wo document bia NDC na implement sa document no ye de beba mo ma di kana kamu nsem because nsem ne de ebia sisi na metena sit dan mu no and let the whole day me see from metena see a me read the document no me hun say yes NDC sa wo no mo ya dia o ka tira sa kesoro krati hwe fam nya sa soro na NDC ni ka tira sa hwe no wo beti woni na anwea one trip na anwea one trip aye wonim say ma na NDC ko and then me fa document no na me share document na nipa no de be all no I gave the person producers for no mo ha o mo ha all na nipa na ko no o Williams ko ye no nyina no e wo sa ayi document we winning 2024 and beyond a comprehensive NDC strategic document ni NDC omo planning 8 years omo wa document ya ebetim do omo akwa aban mu 8 years NDC omo document ya ebetim do omo atena aban mu 8 years na ne a senior member of the party at the Abronye na men kasa bebre me fa page mon fa pages ni nguso page mon mami page ayi page 33 mon mami page 33 ora mon mami yes mon mami page 33 page 35 and 34 assembly wo page 34 mon page 34 page 34 na mo de atosui winning the NDC document winning 2024 and beyond page 34 na mo de atosui and what hello page 34 mo and then me share page 34 no nko page 34 no nko na me share winning 2024 and beyond a comprehensive strategic NDC document MPP4 muntie ne leadership no mfa ompa omunyai page 34 me baba kenkan baby or say engaging the special prosecutor muntie ne ye MPP we ya lama me bro me kan we wie say pemapon page 34 winning 2024 and beyond a comprehensive NDC strategic document 2021 and no more prepare page 34 or say engaging the special prosecutor. Another critical component is engaging with the newly appointed special prosecutor. Mahama must seek a meeting to discuss the ongoing Airbus scandal investigation and persuade the special prosecutor to drop the allegation of bribery and corruption. Comrade Dominic Anyine, who is a partner to the newly appointed special prosecutor at Anyine and Feli, can be instrumental in facilitating such a meeting. The party's release of February 2nd, 2020, issued by the former Attorney General, Marita Brew upon Apia, provides a foundation for this dialogue, offering a nuanced explanation that can help reframe the allegation and facilitate their dismissal. Yapon document no anhwe kura na memfam pebie term agenda what document we mu no kase me di MPP atia eniema what book we mu no eni niema asisi 2024 nyina no me ba be kenkan akire mo how the NDC implement each and every chapter in this document. Say baby o maduru no aye 2028 a o mbefiri ase I implement it and no meeting and Duncan William Koyen. Adrofo ne ahwefo yedamase